Welcome to Limits Exhausted, Texas's Personal Injury Litigation Podcast.
Welcome back to Limits Exhausted, Texas Injury Litigation Podcast with attorney Kiernan McAlpine, founder of McAlpine Law Firm and a board-certified specialist in personal injury trial law by the Texas Board of Legal Specialization. Kiernan has tried more than 40 cases to verdict and is frequently brought in by other attorneys to handle complex, high-exposure litigation involving 18-wheelers, catastrophic injuries, and wrongful death. I'm Shameika Rhymes, and today we're talking about how independent medical exams can significantly affect the direction of a serious injury lawsuit. Welcome back, Kiernan.
Thanks for having me, Shameika.
Well, Kiernan, why does the defense usually request an independent medical exam in a serious injury case?
We like to call them DMEs for defense medical examinations because there's nothing independent about them. So I'll be calling them DMEs throughout the podcast today. I'd say the main reason why defense counsel or defense medical experts like to do DMEs is they diffuse a particular line of cross-examination. Like in a battle of experts in a trial, it's a contest of credibility. It's about a comparison between the plaintiff's experts and the defendant's experts. And one of the easiest comparisons that we can draw with a medical expert hired by the defense who's never seen a plaintiff, never examined him, is just that they haven't seen the plaintiff. They haven't examined him. They haven't seen, they've never seen this person. They wouldn't know him if they were standing on their foot. So that's one of the most common cross-examination lines. And a DME kind of diffuses that because now the expert has seen the plaintiff before. Now they've put hands on him. So, that line of cross-examination is no longer available. And it's easy for us to say, well, who would you trust? A doctor who's never seen you before or one who has? It makes a very easy comparison for the jury. So I think that's probably like the main reason why they want to do it.
Well, can someone be required to attend, and I'm not sure if you want me to call it a DME or independent medical exam, and what happens if they refuse?
You can call it whatever you want, but I'm going to stick to what I know to be correct. Look, it's not automatic. Like, yes, they can require you to do it. The court can require you to do it, but it's not automatic. It's in Texas, for example, it's governed by Rule 204, the Texas Rules of Civil Procedure, which, says that a court can require a medical examination if a specific showing is made. The defendant has to file a motion and supply an affidavit from their expert who's going to do the DME that says, this is why I need the DME and here's what I'm going to do. So if a plaintiff says no, then a defendant simply has to file a motion under Rule 204, and then the judge can say yay or nay, as well as impose limits on what the DME doctor is allowed to do. If the court decides it's warranted, then it's going to happen, and the plaintiff could be subjected to sanctions at that point if they don't do it. So it's no longer optional at that point. Generally speaking, when we're talking about a case that's mostly about physical injuries, if a defendant really wants a DME, they can get one of some kind. Like, it's going to be possible for them to get some type of DME, but what exactly they get and what they're allowed to do, the devil's in the details on that. Mental health DMEs are harder. Like, if they want to assess somebody's, psychological condition or assess for, cognitive impairment, like with a traumatic brain injury, those are a little bit harder to get because they're treated as more invasive. But generally speaking, some type of DME typically will happen if the defendant moves for it. And generally speaking, if you've got a defendant that's motivated to get one, they will get some type of DME.
So it sounds like these aren't necessarily that independent, but how independent are these exams in reality, and who typically chooses the doctor performing them?
They aren't independent. The side that wants it hires and picks the doctor. Typically, a DME will be performed by a doctor who's already been hired, who has already offered some kind of opinions in the case, who's probably already generated an expert report that sets out their preliminary opinions. Like in a lot of cases, doctors will form their opinion just based on medical records. They'll review medical records, they'll grade the homework, they'll make opinions about necessary treatment or what treatment wasn't
Mhm.
necessary. They'll already have a causation opinion. They'll already have alternative diagnoses that they, have to disagree with the doctors that treated the plaintiff. And these doctors know that it's an advocacy role, not a doctor role. There's no doctor-patient relationship that's formed. These doctors are typically frequent flyers. Typically, like, we're very familiar with doctors that do these in the various areas that we practice in, Dallas, Houston, San Antonio, Texas in general. And the experts are there to advocate. It's an intellectual challenge for them. It's a side hustle for them. It can be a very lucrative one, and they understand that they're there to critique the case. So juries already assume that every witness leans towards whoever called them, right? Like, so any witness, whether they're an expert or not, juries will understand whoever's calling this witness or whoever the witness is aligned with, they're probably going to be biased in favor of that side. And experts are no different. And juries also understand that experts are always being paid by one side or the other. So what happens ultimately is, like, there's a kind of a cancellation effect where plaintiff's experts are paid for by the plaintiff, defense experts are paid for by the defendant, and juries understand that the experts are there to render opinions that are helpful for the side that's paying them, and it's jury's job ultimately to decide who's right.
So, what is the defense usually trying to accomplish by sending someone to one of these medical exams?
Other than diffusing the line of cross that you've never seen this person before that I mentioned earlier, a lot of
Mhm.
the time what they're trying to do is they're trying to get more comfortable with an opinion about future medical treatment. Um, you know, Doctors will often do what they call a peer review, which is not really what they're doing. They're grading the homework, and every medical record I've ever seen has some type of mistake, at least one. There's always something to
Mhm.
critique, and they can generally attack past treatment and diagnoses just from the records alone. But when they're wanting to do a DME a lot of the time, I think it's so that they can say, I've seen the plaintiff recently. They seemed fine. It doesn't seem like they need any kind of surgery or future treatment. So I think that's usually like what they're trying to do, is feel more confident disagreeing with a life care plan or surgery recommendation or some kind of ongoing treatment or a diagnosis of permanent injury, something like that.
What kinds of opinions coming out of a DME can cause the most damage to an injury claim?
I'm gonna be totally honest with you. I can't recall a DME ever meaningfully helping a defendant. I mean, there are damage vectors that can exist. For example, there's this thing called Waddell signs where there's malingering tests. Malingering is a fancy word for the person is not hurt and are claiming they are, or they're exaggerating their symptoms. It's faking or exaggerating. So what they'll do sometimes is they'll do these Waddell sign tests where they'll, you know, press on somebody's head very lightly. And if a person is like, ow, that really hurts, it's like they'll do something that shouldn't cause any kind of response and look and see if the person is, you know, claiming pain in response to something that really shouldn't be causing them pain. So, if somebody fails Waddell signs, then that would be, a pretty significant problem. But I can't remember ever having seen that happen in thousands of cases that I've worked on. It's a real risk, but I've essentially never seen it land. I've also seen DMEs be extremely unhelpful to defendants. I've seen cases where, the note showed that a doctor only saw the person for 15 minutes, but they claimed on the stand to have done 85 different tests. So, it's obvious that that didn't happen. So, generally speaking, the defense gains the fact that there's no longer the easy comparison to the treating physician based on whether or not they've seen the plaintiff before. But basically, every other issue stays in the case. It's usually not really transformative in terms of what the outcome is.
So, how often do these DME doctors dispute causation, even when the injury itself is difficult to challenge?
All the time. But the DME typically doesn't tell them anything new. It's the same expert that's doing the DME with an added step. They meet the patient, they ask them questions, and then they perform some type of limited exam. And of course, they aren't, no doctor patient relationship is performed. They can't prescribe treatment. They can't recommend treatment. They can't give a medication. They can't do anything. They're just there to have opinions about it. And those opinions are typically locked in. They're being paid to hold those opinions, and they've
Mhm.
already generally built up an impression of the case based on the records they've already reviewed.
So, are there patterns that you tend to notice with doctors who repeatedly perform these medical exams for insurance companies?
Absolutely. And I won't sugarcoat this one because I've done some retained expert work in the past on
Mhm.
reasonableness of attorney's fees in a case. And I would still work as an expert if the right case presented itself in that same capacity. And when you're an expert on a case, you pick up the file and you look for reasons to justify the position of the side that hired you to do it. Your role isn't as judge, jury, and executioner as an expert. You're not there to analyze the whole case. You're not there to, if I'm doing an opinion on reasonableness of attorney's fees, I'm not there to assess the quality of the underlying lawsuit. I'm not there to say who's right. I'm there to say, yeah, this work looked like it was probably done correctly and it was reasonable and the rate charged for the work was probably correct. Like it's you're not there to tell the jury what the right answer is so much as you are to supply missing technical information. So DME doctors really aren't special in that regard. They're not independent. They're not neutral. And I mean, one of the reasons why it doesn't move the needle that much is that there's still no doctor-patient relationship. The retained expert has no skin in the game, other than that they
Mhm.
can't perjure themselves with opinions. I mean, it's hard to perjure yourself with an opinion because it's an opinion, but they don't have any skin in the game. A treating physician's reputation and medical license is on the line. If they perform unnecessary treatment or they make mistakes when treating a patient, they can be sued for malpractice. Their medical license is implicated. So treating physicians have skin in the game and retained experts really don't. As long as they are continuing to give opinions that are consistent with the party that's hiring them's preferences, they'll continue to get work. So, um, you know, experts rely on the facts that one side claims and that the other disputes, right? So if the defense expert says the plaintiff's not hurt, but the jury thinks they are, then the expert's opinion gets discounted. It doesn't make them a quack. It just means they assumed something that the jury rejected.
So, I'm just asking this question. So, for example, if the injury is, say, like a knee injury, so would a orthopedic type of doctor be retained to do the DME, or is it just a general physician?
Yeah, generally speaking, you need somebody who's specialized in the area of medicine that's an issue. If we're talking about like the actual medicine and what treatment was done, what treatment is needed, what the diagnoses are, what the prognosis is. With life care planning, it's a more comprehensive discipline where that they don't have to be a surgeon to say that a person needs surgery. They just need to have qualifications that would allow them to have an opinion about what type of treatment the person's likely to need if they have a particular kind of injury. But, if the plaintiff has claiming a knee injury and, a knee orthopedist says they need a knee scope, then if the defendant wanted to challenge that with, a retained expert, they would typically have to be at least an orthopedic surgeon. Again, like the comparison is the battle of the experts, right? So if they hire an orthopedic surgeon that specializes in spines to say there's nothing wrong with the knee, a knee surgeon's opinion that there is something wrong with the knee would typically carry more weight. So they're generally going to find experts that have the specialization and the subspecialization that's relevant to what the person is claiming in order to contest it.
Well, have you seen cases where a DME report dramatically changed settlement leverage or completely shifted the direction of the litigation?
Honestly, not really, but it could. For example, I mentioned earlier failed Waddell signs test. That's a potential
Mhm.
leverage point. If somebody is claiming that they were suffering pain in response to a stimulus that shouldn't cause pain, and that's documented. I mean, there's a question of whether we would believe the expert that that's actually what happened, but that's a potential leverage point. Additionally, it's super rare, but I've heard stories about it happening where the DME doctor finds that a surgery recommendation was reasonable. Typically, at that point, you'd never see the report. The defense lawyer would call you and say, "Hey, can we work this out?" And they would try to bury that. But rare, but it could happen, and that would change the landscape. But most often, we know what the defense expert's going to say. before the DME ever happens, and that's what they say. It's all very predictable, and it doesn't really change the outlook of the case.
And to wrap up, how do plaintiff attorneys challenge a DME report they believe is biased or unsupported by the medical evidence?
Primarily cross-examination. I mean, the best way to prove an expert wrong is through cross-examination. There are ways to get experts removed from cases. There's what's called a Daubert motion after a federal court case that made it to the Supreme Court called Daubert. In Texas, it's called Robinson is the parallel case. And those cases talk about what an expert needs in order to be able to render a reliable opinion. And the judge gets to act as a gatekeeper for junk science or otherwise unreliable opinions. Like I think the case law says, just because you're an expert doesn't mean you can testify that 2 + 2 = 5 or that the moon is made of green cheese. So if an expert's opinions are really, really out there, it's possible to challenge them. I see a lot more motions to challenge experts coming from the defense side because they've got an insurance adjuster willing to pay them to do it. Whereas I think plaintiff lawyers more likely will only file these types of motions if they're like highly confident that it's going to work. But it's hard to be confident about it because the easiest way to get an expert struck is if they're not qualified. And typically the experts that are being hired to do this type of work are of the right specialization and have at least decent resumes, if not impressive resumes. So it's hard to get an expert struck based on lack of qualifications. And generally, judges are going to say that whatever points you want to make about why they're wrong, you can just cross-examine them about that and argue it to the jury. So we can get sometimes like really egregious opinions or unsupported opinions pruned away from the case with the motion to limit. But more often than not, we just use good old-fashioned cross-examination at trial to get these experts put in their proper place. And it's ultimately the jury's job to decide who's telling the truth and who's not.
Well, thank you so much, Kiernan, for breaking this down for us today. This was super informative.
Absolutely. Always happy to do it.
Well, that wraps up this episode of Limits Exhausted, Texas Injury Litigation Podcast with Kiernan McAlpine of McAlpine Law Firm. If you're dealing with a serious injury case involving complex litigation issues, visit McAlpineLaw.com to learn more. And be sure to like, leave a review, and subscribe so you don't miss future conversations on high-stakes injury litigation in Texas. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.